Hello, everyone, and thank you for joining today's webinar talking about managing international data transfers. I'm just going to give it a few moments and let people enter this facsimile of a room. I will mention at the start from the outset, we're going to leave some time for Q&A at the end. And so if you have questions throughout the webinar, please feel free to put those in the question and answer part of the chat. So don't go to the chat, go to the Q&A and put your questions in there so we can address those and get to those at the end of the webinar. So today we're going to be discussing managing international data transfers, in particular focusing on transfer impact assessments. I know tons and tons of businesses, companies, and organizations are still dealing with the challenging aftermath of that Schrems II decision, despite that decision coming down nearly 2 years ago at this point. So we know that more than 7 in 10 companies are transferring data from the EU to a third country, and the majority of them use standard contractual clauses, about 94% of them. And when you are using standard contractual clauses or any of those Article 46 safeguards, you have to conduct a transfer impact assessment. So with that, I'll go ahead and get started. First, I want to say a few words about Wrangu and who we are. As the host of this webinar, we are an elite ServiceNow partner providing flexible software solutions for integrated risk security and privacy management. We were founded in 2016 with the mission to enable our clients to maximize the value from their ServiceNow investment through world-class implementation and services, and the creation of intelligent apps, helping to solve localization needs and address industry-specific challenges that our clients have in their business. We've delivered over 200 GRC security ops and data privacy projects across 18 industries and 15 countries. And this transfer impact assessment is something that is embedded within our Privacy Hub product. So with that, I'll give just a little bit of an introduction about myself. My name is Stephen Ragan, and I'm a data protection and privacy consultant here at Wrangu. My background is legal. I'm an American lawyer and a member of the bar in Washington, D.C., but for the past half decade, I've been working on compliance with GDPR, and I'm also an affiliate fellow at the Center for Internet and Human Rights. So here's our agenda for the day. I just want to lay out very briefly the contextual situation and discuss that Schrems II decision before laying out the Chapter 5 transfers and the transfer tools under the GDPR. Article 46 is not the only mechanism you can use to transfer data, and I want everybody to be aware of that, though of course I'm sure you all are. Before I turn to really the meat of the webinar, discussing those transfer impact assessments and really answering those questions, what they are, when do you have to conduct them, and then ultimately, how do you do that? And then I will mention also in brief the differences between the EU and the UK. UK obviously going its own way following Brexit. They've implemented the UK GDPR with some subtle differences therein. And then I'll conclude with some last thoughts, mentioning in brief that in principle agreement between the US and the EU and kind of what that means for your business going forward, before, again, leaving some time at the end for Q&A. So thinking about the contextual situation, how we got here, of course, we're all, in some sense, probably familiar with the Schrems II decision. That was a decision handed down by the Court of Justice of the European Union back in July of 2020. And it kind of addressed a number of issues, but the main ones that we need to concern ourselves with here was this question of whether or not standard contractual clauses were valid, as well as whether or not the privacy shield, which was the transfer mechanism between the EU and the US, under which US businesses and organizations could certify, whether that privacy shield ensured an adequate level of protection. So in brief, the facts were a complaint was brought by Max Schrems against the Irish Data Protection Commissioner relating to Facebook's data transfers to the US. The ultimate outcome of that decision was that Privacy Shield was invalid, but reaffirmed the validity, the court reaffirmed the validity of the standard contractual clauses. And the court reasoned that the US surveillance program was not limited to what was necessary and proportional, as well as there being a lack of judicial redress for data subjects and a place for them to enforce their rights under the GDPR. And these are some lingering issues that we are still dealing with, especially as the EU and the US are negotiating an updated privacy shield. So some other big takeaways from the Schrems II decision was that exporters, so I want to highlight this and I will repeat this throughout the presentation. It's exporters. So those are either controllers or processors who are exporting data from the EU or the European Economic Area outside of the EU to a third country. So it can be, again, either controllers or processors. It's whoever's exporting that data. Using Article 46 transfer tools must verify whether the law of the third country of destination ensures adequate protection under EU law. And organizations are required to verify this prior to any transfer. So, that's kind of the contextual situation. That's kind of what we're dealing with. And then we get to shortly thereafter, after the Schrems II decision, we had the European Data Protection Board publish some guidelines and recommendations on supplemental measures for international data transfers. They laid out 6 steps that organizations should take in and a process for considering some of those issues and some of the contextual situation for your data transfers. And I'll basically follow at least the first 3 steps as I give this presentation. So I'm going to focus on knowing your transfer and the way we can solve that and the way we solve that here at Wrangu in our privacy hub. Then identifying your transfer tools, whether that's Adequacy, Article 46, or those derogations. I will in brief touch on those. And then step 3, that is conducting that transfer impact assessment and assessing whether or not the Article 46 transfer tool is effective in light of the circumstances of the laws and practices in those third countries. Then the 4th step is adopting supplementary measures, if we can do that to kind of fill those gaps that we identify in our TIA. And then, procedural steps to implement those supplementary measures, and finally, reevaluating at appropriate intervals. So I'm really going to focus just on those first three steps. And kind of that conclusion of that assessment is really up to businesses and organizations. We're laying out the process, giving them the questions to go through, as well as the tools to understand their data flows. So with that, I just want to highlight in brief, this is a snapshot of what we call our data flow mapper in the Privacy Hub product. So in this example that we have here, we have an organization in France that's collecting data from an employee and is transferring data in 3 separate scenarios. So in the first scenario, we have a data transfer from France to the United States. Of course, France is the EU. Transfer is going outside of the EU, so we have to conduct a transfer impact assessment. That's a fairly straightforward example. In the second example, we have a transfer from the French organization to a processor in Germany. So it's a data transfer within the EU. No transfer, no TIA has to be completed. However, we see that there is then an onward transfer of the data from the processor to a sub-processor in India, as well as a controller in Portugal. So in this instance, the processor has to conduct a transfer impact assessment for that data transfer to India. Again, I want to highlight this as a processor, but nonetheless, they are the organization exporting the data from the EU, and therefore they have to conduct a transfer impact assessment. It's also prudent of the French organization to consider conducting a transfer impact assessment, because you have to also consider envisaged or envisioned data transfers that go the onward data transfers. So from your processor further down the line. But it is certain that the German organization, the German processor here, has to conduct a data transfer. Then we have the third example. Again, French organization. It's not clear exactly who or where the controller is located. I just wanted to again highlight, for the purposes of this example, that even data transfers, if they are processor to controller, if that French organization is a processor, the controller is outside of the EU. Nonetheless, this French organization would also have to conduct a transfer impact assessment. So again, this is following the EDPB guidance on that first step to know your data transfers. With our data flow mapper, we kind of just lay that out in a visual form and kind of try to make that, as easily digestible as it can be for organizations to plot out their data transfers. Then we have the second step. So identify your Chapter 5 transfer tool. As I've mentioned, there are more options than just the standard contractual clauses. And the suggestion is that first you want to see whether or not there is an adequacy decision in that third country. Because if that's the case, then you don't have to put on any additional safeguards to your data transfers. You can just transfer the data to those third countries. This is a constrained environment. Adequacy decisions are those given by the EU Commission, and they relate just to these countries that I've listed here: Andorra, Argentina, Canada, Faroe Islands, Guernsey, Israel, Isle of Man. I don't have to name them all. You see them there, and they're quite easy to look up. So when you are considering, transfers outside of the EU, first step is to look to see whether or not there is an adequacy decision. From there, you consider your Article 46 transfer tools, but I wanted to pair this with the Article 49 derogations, just for simplicity's sake. Derogations are also an option. They're considered the option of last resort. And as the text says in the GDPR, you consider derogations in the absence of an adequacy decision or of appropriate safeguards under Article 46. And the conditions for using derogations are fairly strict. So the data has to be transferred for occasional and not repetitive transfers. And there is a necessity test under subparagraph 1B, C, D, E, and F. The only one that doesn't have this necessity test is explicit consent. So first consider whether or not there's an adequacy decision. Then you look to Article 46. That doesn't work out. Look to whether or not you can use derogations. And we have more than just standard contractual standard contractual clauses under Article 46. We have legally binding and enforceable instruments between public authorities or bodies. It doesn't really apply to businesses and organizations, but binding corporate rules is also a potential option. Of course, most companies are using those standard contractual clauses. And then I want you can all just be cognizant that there is the option for approved codes of conduct or certifications, but in practice, none of those have been yet approved. So if you are relying on Article 46 transfer tools, then you have to conduct a transfer impact assessment. So what exactly is a TIA? Well, it's really addressing the question of whether or not there's anything in the law and or practices that impinge on the effectiveness of the safeguards in that transfer tool. What that essentially means is that, if you're using standard contractual clauses, this is a contractual relationship and there's a contractual obligation between the exporter and the importer, but that contract cannot tie, public authorities or national security agencies or anything like that. They're not a party to the contract. And so, they don't have to abide by your contractual clauses, which kind of creates, of course, a really challenging situation for most organizations. So you have to conduct a TIA. So when do you have to do that and who do you have to do that? I've already mentioned most of this already, but I will just, repeat it for everybody's sake. So again, if you're using an Article 46 transfer tool, you must conduct a TIA prior to any transfer. Obviously, in practice, organizations have not always conducted this TIA prior to the data transfers. Maybe there are ongoing data transfers that don't have a TIA, but nonetheless, you should conduct a transfer impact assessment for those data transfers as well. We're really concerned under the law of following this process and also complying with those principles like accountability and being able to demonstrate your compliance in the case of an audit. Now, those TIAs must be conducted on a case-by-case basis, again taking into account those envisaged onward transfers. Within our tool, we give you the option, to clone TIAs, so you don't have to do the entire thing every time, especially if the data is being transferred to the same country or the same economic sector or something like that. There are aspects of the TIA that can be cloned and reused and kind of create some efficiencies and time-saving tweaks there. And then again, it's exporters must conduct a TIA. This includes either controllers or processors. It's whoever's exporting that data outside of the EU. So, meat on the bones. How do you conduct a transfer impact assessment? Well, within our TIA, we break it into 4 parts. And the first part is concerned with laying out, the circumstances of that transfer. So where is the data being transferred and where is it going? So, some of the stuff we can definitely draw out of like Europa or draw from that data flow mapper and autofill. So you don't have to do, everything every time, but nonetheless, I just wanted to give everybody kind of a set of examples for the questions and considerations to make. So when you're considering the country of the importer, are there any onward transfers? And then do you have to conduct additional TIAs for those countries as well? And again, are there aspects that can be cloned? And then the context of the transfer, what is the purpose of the transfer? Maybe we can draw this from the record of processing activities. What sectors are involved in the transfer, what categories of personal data, what types of personal data are being transferred. These are all particularly relevant. Certainly considering where you are transferring that data. So if you're transferring it, for example, to the United States, there is not, an overarching privacy and data protection law, but there are sectoral specific laws, for finance and for children's personal data or for health data, for example. And then of course, you have that designation of electronic communications providers that fall under that Federal Intelligence Surveillance Act that was of chief concern to the Court of Justice in that Schrems II decision. Conducting a TIA is in some sense a risk assessment. So is there any sensitive data involved? That of course creates a heightened risk to the rights of data subjects if there is some type of access to that personal information. Then the final consideration in our first part, is the technical implementation of the transfer. Is the personal data being accessed remotely, or is it going to be stored within that third country? So again, creating the circumstances in the context of the data transfer. And then in the second part, it's really honestly the critical aspect of it, assessing the laws and practices of the third country. So, what are the relevant local laws? And this requires, some interplay and a relationship with your importer. Like, can you make this TIA, this questionnaire exportable? Can you send it? I mean, within our product, you can do these things, but this is also, a consideration for all organizations to get, some assistance from local organizations, local businesses, and the local importers, because it's really challenging, of course, to know all the laws and practices of all the countries where you might be transferring that personal data. And then, this part of the questionnaire can draw from, as the entire TIA does, that clause 14 of the standard contractual clauses, as well as those considerations that came out of that Schrems II decision. So whether or not, the importer is required to grant access to public authorities, basically all countries have national security laws, but are those authorities constrained by those principles of necessity and proportionality? Is access to personal data constrained by the principles of legality? So are there clear, precise, and accessible rules? And is that access to data subject to independent judicial review, as well as whether or not there's judicial redress for data subjects? So drawing out a lot of the considerations from that Schrems II decision. And then you can also draw on the practical experiences of the data importer. If it is an electronic communications provider, maybe you can get really specific and really narrow. So has that importer experienced prior instances of requests? Has that importer, if it has experienced prior instances, was it for similar types of personal data that is being transferred in this situation? Again, those considerations cannot be dispositive. Cannot, whether or not there hasn't been or has been a request cannot define whether or not you can transfer the data. But nonetheless, it can be a question and it can be a consideration involved in your transfer impact assessment. So once we've considered the context of the situation, the laws and practices of the third country, we have this third part. So considering what technical, organizational, and contractual measures are in place to supplement those Article 46 safeguards. So of course, the initial basic question is the personal data protected by an approved transfer mechanism? Are you using standard contractual clauses or binding corporate rules or one of the other mechanisms for transferring the data? What measures do you have in place for transmission and in place where the data is being transferred? There have been a number of cases in the EU that have tried to lend some clarity to what technical and organizational measures we might be able to put in place to solve some of these challenges. So from the French courts, we had a decision that concerned Amazon Web Services and the encryption of data with the cryptographic key stored within the EU. And this is with a third company. So this is particularly important. If the organization, the importer where you're transferring the data does not have the means of accessing that personal data, then they can't grant access to public authorities. So one way to get around that is to just encrypt the data and then keep the key stored in the EU, because American keep harking on the United States as an example, but that's what came out of that's what the Schrems decision was based on. And the national security agencies and the public authorities in the United States can compel American organizations to grant them access, as well as access to their cryptographic keys. So in that French decision, it was particularly dispositive that the cryptographic key was stored in the EU away from access from American public authorities. So that's one way to get around it. Another outcome from that decision was having contractual measures in place for organizations to defend against access requests and putting aside resources to support those requests. I mean, of course, that's can be dispositive as well, but there are mechanisms that we can go about to try to fill in those gaps. And I can't give you them all here. I mean, I don't have the laundry list. I'm sure you have 100 yourself, and so it's definitely something to keep in mind. There are another couple of resources that you can look to as well, from the Austrian Data Protection Authority, as well as the French Data Protection Authority, and their decisions around the use of Google Analytics and their reasoning and the discussion that they have within their decisions related to some of these technical and organizational measures that, well, in that example, in that instance, didn't really pass muster. So I think going above and beyond what they did there is kind of a necessity. So consider first the context and circumstances of the data transfer, assess the laws and practices in the third country, and then explore and process and document what your technical and organizational measures are before getting to that fourth part. And this is ultimately the decision of businesses and organizations to assess the effectiveness test, so the effectiveness of those safeguards, of those Article 46 safeguards. Asking that question, is the data transfer tool effective in safeguarding an essentially equivalent protection with the GDPR in light of the third country's legislation? And then considering, is the risk of access by public authorities sufficiently low to allow the data transfer? Again, these are ad hoc decisions by businesses and organizations. TIAs lay out the process for evaluating your situation, evaluating the laws and practices, but it's ultimately up to businesses and organizations to make that ultimate decision about whether or not they want to transfer personal data. And once you've considered that effectiveness test, you can also, again, are there any additional supplementary measures that you can put in place to fill the gaps? And again, that ultimate decision lies with businesses and organizations who are laying out the process and the questions to ask, and documenting that and being able to demonstrate accountability, transparency, and compliance with the GDPR and those principles. So that's basically our 4-part test. I've just laid it out in question format. I can't give you access to everything, or just some considerations to keep in mind. Of course, at the end, I will give you an email address to contact us if you want to learn more about what we are doing with our Privacy Hub. But before that, I want to mention just in brief some of these differences between the EU and the UK. As I've mentioned, as you are surely aware, the UK is no longer part of the European Union, but they still have their version of the GDPR that essentially mirrors the European Union's. There are some subtle differences between the standard contractual clauses that were promulgated by the EU and what the UK has gone ahead and promulgated themselves, which came into effect March 21st, so just last month. Their version of the standard contractual clauses called the International Data Transfer Agreements. So those can fill in for the standard contractual clauses. In the UK, you can't use the EU standard contractual clauses, but what you can do is use this addendum and add an addendum to the EU standard contractual clauses. So you kind of facilitates and makes things a little easier. In the UK, you can still use the old standard contractual clauses from, I believe, 2011 for new contracts until September of this year. And that will provide safeguards until March of 2024. The UK is also undergoing, and I believe it's still in a draft stage, but its own version of the transfer impact assessment called the transfer risk assessment that will, at least the draft has it in 3 parts, again, assess the transfer. Is the transfer agreement enforceable in the destination company, and whether or not there's appropriate protection from third-party access. So many of the same considerations from the EDPB guidance will likely be in effect in the UK as well. And then just some brief final considerations. In the EU, you can actually use the old standard contractual clauses as well until December of this year. However, for those were for contracts concluded before September of 2021. So for any new contracts, you have to put in place the new standard contractual clauses, and then keep in mind that you have to replace the old ones by December 27th of this year. And then I just wanted to discuss just in brief this US and EU in principle agreement and kind of what that might mean for businesses and organizations going forward. So, of course, it's important for us to keep in mind that this was just a political agreement. There's been no publication of a legal document. And it's not quite clear when we will get that. I know there is speculation that maybe before the end of the year. It's a possibility. I mean, it seems quite clear that there will be some type of an agreement that comes out. The presidents of the United States and the EU, they're not going to make this agreement and make this big publication if there's not something that's going to be coming, but it's still really unclear how the US is going to achieve and solve some of those issues that were presented in that Schrems II decision. There's a lot of partisan bickering in the legislature, in Congress, And so it seems really unlikely, despite continued promulgation of messaging from businesses to individuals about wanting federal privacy law. It seems still nearly off the table as something, because they can't seemingly agree on anything. So there's the possibility that maybe President Biden will sign some executive order. But executive order is what one president signs with a pen can be undone by the next administration. So it kind of creates definitely an uncertain environment. And then of course, we have the situation of if and when we get the legal agreement, whether or not we will then turn to and have a third Schrems decision. Of course, Max Schrems was asked for comment on the agreement and said, wait for the legal agreement, and then, who knows. But those were some of my concluding thoughts on that situation, as well as laying out, the situation around the standard contractual clauses and when you can and cannot use them. And now I will open up the floor to some questions. So again, if you have any, please go ahead and type them in the chat. I know that transfer impact assessments are in some sense really a challenging thing for businesses and organizations. Of course, I mean, we are nearly a year and a half, almost 2 years since the Schrems decision, and all the time, businesses and organizations are coming to us asking us, how to solve these challenges, how to get around them, and how to manage international data transfers, because data transfers, they're really, like, in some sense, the lifeblood of our new digital environment. So let me open up the Q&A and see what we have in here. We'll look at the chat as well. But it looks like we don't have a bunch of questions. So with that, I will, so I have something in the chat. Is it practically possible to require data processors to conduct TIAs for their solutions, including on-board transfer subprocessors in the data protection agreement? I mean, that's contracts are those require negotiations. So I mean, if you put it in your contractual agreement and the processors sign it, then there is, of course, that obligation to conduct the TIA based on contractual requirements. I would also keep in mind that if the processor is the one exporting the data, they have an obligation by law to conduct a TIA as well. This does kind of create kind of a complex situation where there's the potential for outsourcing of these TIA requirements. So that's kind of a concerning situation, perhaps as well. But nonetheless, in your records of processing activities, you also have to document your data transfers, including those emphasized onward transfers. So it is best practice as well, certainly for controllers to go about and conduct TIAs as well. Of course, for that, those principles of accountability and being able to demonstrate compliance and transparency and all of that. Then I have a question. Do you have a TIA template? I mean, we do have a TIA template. I kind of gave one in the slides. I do think that we are going to publish these slides. But I can't give everything away. So I will put an email address on the next slide, as well as I think, and you can contact me as well if you have follow-up questions. Then we have there's another question here. It's a long one. I'm the controller and exporting data to a Canadian processor under the Canadian privacy law. All fine. However, they use a US subprocessor. Do I have to do a TIA regarding that subprocessor? Yeah, so I would say yes, because again, you have to consider your onward transfers. I know Canada has an adequacy decision, but again, you have to consider those onward data transfers. So I would say yes in this situation. Then you should conduct a transfer impact assessment, and working with AWS and sending data to the US is a really complex and fraught situation. In my standard data processing agreement, I have a clause saying processor must sign standard contractual clauses, etc., with subprocessor in order to ensure that our data is secured. Canadian processor can't guarantee, so proposes standard contractual clauses. Makes that sense? What about the different modules in the standard contractual clause? So I think so yeah, I mean, there are the different modules in the standard contractual clause. I'm not exactly on the fly sure I'm understanding this question. Processors, there are the options, of course, for processor to processor data transfers under the standard contractual clause. Yeah, I mean, there are the four modules: processor to controller, controller to controller, etc. So if that's not clear, you can follow up with me afterwards. Then maybe I have a little more time to process the questions. Then we are seeing a lot of resistance from processors in sharing their TIAs with us for onward transfers. They often cite that the template is commercially sensitive. Do you think that a processor should be sharing this or just confirming it has been done? Yeah, this is a kind of a challenging situation where you might want to reconsider, your relationship with the processor here, if they're not, in some sense having this or trying to rely on a good faith relationship. I don't think that's that really satisfies concerns that controllers or your organization should have about where the data is being transferred. On the one hand, as well as those technical and security measures in place, as well as are they making those appropriate considerations for your organization, for your risk profile? I think these are all things that you need to be considering as as your organization picks its importers, picks its processors and subprocessors. And I think with that, I'm gonna go ahead and thank you all for taking the time to send your questions in. Thank you for taking the time to attend this webinar. If you have any questions about us at Wrangu, you can reach out or you can visit our webpage at wrangu.com or send us an email at data.privacy@wrangu.com. Or if you have questions for me, you can send me an email as well, and I'd be happy to answer those. And my email is steven.ragan@wrangu.com. You can find that on one of the earlier slides, and I do think that we are going to be sharing these slides. So again, I want to thank you all for attending, and have a good rest of your Thursday and a nice weekend, and good luck with all your international data transfers going forward.